Members of the jury, hearken to the indictments in the case of Commonwealth versus Aaron Hernandez. Indictment 2013-983-A, charging murder. At the Superior Court holding at Fall River, within and for the County of Bristol, for the transaction of criminal business on the first Monday of July, 2013, the jurors for the said Commonwealth, on their oath, present that Aaron Hernandez, on or about June 17, 2013, at North Attleboro in the County of Bristol aforesaid, did assault and beat Odin Lloyd with intent to murder him, and by such assault and beating did kill and murder the said Odin Lloyd in violation of General Laws, Chapter 265, Section 1, a true bill signed by the foreperson of the grand jury and the Assistant District Attorney. Indictment 2013-983-B, charging unlawful possession of a firearm while not at home or work. At the Superior Court holding at Fall River, within and for the County of Bristol, for the transaction of criminal business on the first Monday of July, 2013, the jurors for the said Commonwealth, on their oath, present that Aaron Hernandez, on or about June 17, 2013, at North Attleboro, in the County of Bristol aforesaid, did knowingly have in his possession or under his control in a vehicle a loaded or unloaded firearm as defined in General Laws, Chapter 140, Section 121, the defendant not being present in or on his residence or place of business, and not having in effect a license to carry firearms or otherwise being authorized or exempted by statute so to do, in violation of General Laws, Chapter 269, Section 10A, a true bill signed by the foreperson of the grand jury and the Assistant District Attorney. Indictment 2013-983-C, charging unlawful possession of ammunition without an FID card. At the Superior Court holding at Fall River, within and for the County of Bristol, for the transaction of criminal business on the first Monday of July, 2013, the jurors for the said Commonwealth, on their oath, present that Aaron Hernandez, on or about June 22, 2013, at North Attleboro in the County of Bristol aforesaid, did own or possess or transfer possession of ammunition without complying with the requirements relating to the firearms identification card provided for in Section 129C of Chapter 140 of the General Laws, in violation of General Laws, Chapter 269, Section 10H, a true bill signed by the foreperson of the grand jury and the Assistant District Attorney. To these indictments, the defendant has heretofore pleaded that he is not guilty, and for trial has put himself on the country, which country you are. You are now sworn to try the issues. If he is guilty, you will say so. If he is not guilty, you will say so, and no more. Hearken to the evidence.
As we begin, I want to tell you a few things about the trial of cases generally. At this time, in this case, there are 19 judges. You 18 men and women are the judges of the facts. You're the only judges of the facts. You alone determine what evidence to believe, how important the evidence is that you do believe, and what conclusions all the believable evidence leads you to. Ultimately, you must determine whether or not the Commonwealth has proved the charges beyond a reasonable doubt. You will have to consider and weigh the testimony of all the witnesses who will appear before you, and you alone will determine whether to believe any witness and the extent to which you believe any witness. The testimony of a law enforcement officer is to be treated the same as the testimony of any other witness. You must determine the facts based solely and entirely on the evidence as you see it and hear it right here in this courtroom, and on anything you may observe about the layout of the locations you see when we go on a view, and on nothing else whatsoever. No bias, no prejudice, no fear, no sympathy for anyone. Before the case will be presented to you, there are a number of aspects we should touch upon. First, keep your mind suspended throughout the entire trial proceeding. By that I mean don't stop making up your mind. You've heard no evidence at all yet, and when we stop taking evidence, the last witness is as important as the first, and the first as important as the last. So keep an open mind. Don't make up your minds while it's going along. Next, when you come into the courthouse, do not stop in any of the public areas inside or outside of the courthouse, but go directly to the jury room. The jury room will be your headquarters for the remainder of this trial. At no time should you use any entrance other than the one designated for jurors. Also, please park in the designated juror lot, and please be prompt. You should arrive at the parking lot between 8:15 and 8:30. As I have repeatedly instructed you, you cannot talk about this case, your jury service, or Mr. Hernandez with anyone, and do not allow anyone to talk to you about any of these things. This applies to communications with each other. Discussions can lead to conclusions being drawn or positions taken prematurely. Fairness requires you to keep an open mind about everything, and therefore you cannot discuss this case with each other until I instruct you to begin your deliberations. This prohibition against communications about this case, your jury service, and Mr. Hernandez applies as well to family members, friends, acquaintances, strangers, members of the media, co-workers, and employers, as well as lawyers, witnesses, and parties involved in this trial. You can notify your family and your employer that you are on jury duty and discuss the schedule if they need to know that, but please do not otherwise discuss any aspect of this case or Mr. Hernandez, including even that you are a juror on this particular case, until your service as jurors is complete and that you have been discharged by the court. The Jury Commissioner's Office will send you an official statement of your days of service in this case within a week or so after your service is complete, and you may show or give this form to your employer to confirm that you had served as a juror. If before that time you need confirmation that you are serving as a juror, please let the court officers know, and we'll give you a document confirming you're here with us as a juror. When I say you cannot talk about certain matters, I don't just mean face-to-face or telephone conversations. You cannot at any time before you are discharged as a juror communicate information about or in any way relevant to this case, Mr. Hernandez, or your jury service by using a mobile phone, computer, or any other kind of electronic device with communication capabilities, including access to the Internet. You cannot use the Internet or any text or instant or online messaging service or any chat room or blog or website, Facebook, LinkedIn, Twitter, Instagram, YouTube, Snapchat, or any other means to communicate anything about this case, Mr. Hernandez, or your jury service. And do not allow anyone to talk to you about this case, your jury service, or the defendant. Please remove yourself immediately from any conversation in which the case, Mr. Hernandez, or anything that might be relevant in any way to the case is being discussed. If anyone approaches you to discuss the case, you must decline to do so. If anyone persists in asking you about it, please inform one of the court officers immediately. Next, do not read, watch, or listen to any accounts of any aspect of this case. Anything that might be relevant in any way to the case, or anything about Mr. Hernandez in any news media outlet, social media, or other forum. Television, radio, newspaper, magazine, internet site, social media, or any other source. You must completely disregard any information that you might encounter. it would be unfair to consider information from such sources because it is not evidence, and the parties will have no opportunity to challenge it or to challenge the accuracy of the information or to explain it. If despite your best efforts to avoid any news or social media reports or references, something comes to your attention, it is your sworn responsibility to put it aside immediately and to direct your attention elsewhere. Turn off or walk away from the TV, radio, or computer or electronic device, or put the newspaper down or other printed matter. In fact, you can take steps to try to avoid anything. If you look at a newspaper, have someone else cut out anything if there's anything about Mr. Hernandez or this case. If you go onto Facebook, if there's someone else that can look at it to make sure that there's nothing on the Facebook site that has that comes on when you turn it on that has anything to do with this case. Similarly, if you go to any news site on the internet, someone could look at that site to see that there's no headlines or anything that you might inadvertently come across. You also cannot conduct any investigation into any aspect of this case or try to get any information on your own about the case or do any research about the case or anything you think might be relevant in any way to this case or to Mr. Hernandez. That means no looking up anything in a reference book, encyclopedia, dictionary, or the news media. As I already told you, you may not try to get information by communicating with anyone. You also may not use any printed or electronic sources to seek out information about this case or about any of the issues or people involved in this case. That means no use of the internet, any internet service, any text or instant messaging service, any chat room, blog, or website, Facebook, LinkedIn, or YouTube, and no use of Twitter or Google, Yahoo, Safari, or any other search engine to conduct any research about this case or anything you think might be relevant to the case or the people involved in this case, or to receive any information about the case, Mr. Hernandez, or your jury service. You may not visit on your own any of the places involved in this case, and you cannot locate any areas about which you'll be hearing testimony by using internet maps or Google Earth. And do not ask or allow anyone else to do any of these things on your behalf. You cannot use for any purposes a computer or mobile phone or other electronic device while you're actually here inside the courtroom or during jury deliberations. You may use such devices during breaks, but once again, not to obtain or disclose any information about or relevant to the case. If any juror is exposed to outside information or if any juror has not followed these instructions, please notify the court officer in charge of your jury panel as soon as possible. I will be asking you each day whether you've had any difficulty in complying with these instructions. The reason for these cautions are simple but critically important. In order for your verdict to be fair, you must decide the case solely on the basis of the evidence and the law that is presented to you right here in the courtroom, and not from any other source. According to the oath which you have taken as jurors, you promised that you would well and truly try the issue between the commonwealth and the defendant according to the law and the evidence. Any independent or outside information or influence would be improper and unfair to the parties. We need to ensure a fair, just, and equitable trial for all parties in this case. Next, you have the permission of the court to take notes, and so after the opening statements, one of the court officers will pass to each of you a notebook and a pencil. Your notes are private. At the end of each day, the notebooks will be collected and kept locked up overnight. No one but you will look at your notes. And when the trial is over, after you have finished deliberating, any notes that have been made will be destroyed. The notes are for you. The fact that I allow you to take notes does not mean that you have to. Many people understand things better if they're not distracted by taking notes, and of course, that's perfectly appropriate. You don't have to take notes about anything. Even if you do take notes, remember, most of your work in this trial must be done with your eyes, your ears, and your mind, and not with your fingers. So if you take notes, do so sparingly. Do not allow note-taking to distract you from your critical task of passing on the credibility, that is the believability of the witnesses. To assist you in passing on the credibility, you should observe the demeanor and appearance of each witness on the witness stand here. Now, it's appropriate for the lawyers as they examine witnesses sometimes to approach a witness. But if a lawyer steps between you and the witness and you can't see what the witness is saying as the witness answers the question, please raise your hand. I'll ask the lawyer to move so you can watch the witnesses as they answer the questions. It's also possible that a witness may drop his or her voice. If you can't hear, raise your hand. And the same is true of questions posed to witnesses. If you cannot hear what the lawyers are saying, do not hesitate to raise your hand, and I'll ask them to speak up. Generally, not today, but generally, I will be taking a recess every day at approximately 11 o'clock in the morning. On days when we are going to 4 o'clock, there'll generally be a lunch recess between 1 and 2. If any of you need a break other than at the usual time, please do not hesitate to raise your hand, and I'll stop and take a short recess. If it becomes necessary during the trial to communicate with me, you may send me a signed note through the court officer. Please do not communicate with me by any other means. As I've told you during this case, you may not communicate with the attorneys, witnesses, or the defendant at all. If you see any of them, they will not acknowledge you, or they'll walk the other way. It's perfectly appropriate, as we listen to the testimony of the witnesses, for a lawyer to object. In raising objections, the lawyers are carrying out their duties as trial lawyers, and you should not look negatively in any way on a lawyer who makes an objection. A witness is asked a question, a lawyer says objection, and then there's a ruling. I tell the lawyers, really, they're very skilled in the law, but I have the deciding power. I decide how the law works in this specific case. I may say sustained, which means that the witness doesn't have to answer the question, and you should disregard the question and not speculate as to what the answer might have been. Or I may say overruled, in which case the witness will answer the question, but don't give that answer any more weight than you would have given it had no objection been made. Sometimes the witness will answer the question before I rule, but I may still decide to sustain the objection or allow a motion to strike. If that happens, or if I say strike it out or disregard it, or words to that effect, then insofar as is humanly possible, you have to blot out what the witness has just said, because I will have decided that it plays no part legally in the trial of this case. Now, questions to witnesses, no matter how artfully phrased, are not evidence. Oral evidence consists only of the answers that you receive from the witnesses who are testifying under oath. Now, from time to time, I need to consult with the attorneys about questions of law that come up. We usually do that over there, what we call the sidebar. You saw us go over there when you were chosen. Or sometimes a recess will be called or the start of the trial delayed. I don't want you speculating about that. It will be necessary and perfectly appropriate from time to time to have such conferences about the law as matters come up during the course of the trial. If we are over there huddling, you should feel free to stand up and stretch, but please don't talk. When I rule, or if I instruct you on the law, or if I ask a question, do not take any of my words or expressions as any indication of my own opinion as to whether the Commonwealth has met its burden of proof in this case. If you come to believe during the course of the trial that I have any opinion as to any issue of fact, then disregard it. That is your area of responsibility, and yours alone. Let's come to this case now. The Commonwealth brought this case. The Commonwealth made these charges against Aaron Hernandez. You should clearly understand the pieces of paper which the clerk has just read to you, called indictments, are not themselves any evidence of guilt. An indictment is merely a piece of paper used to formally inform the defendant of the charges against him. An indictment is not evidence of anything. You must not draw any inference of guilt from the indictments or the fact that the defendant has been charged with a crime. The Commonwealth has to prove each essential element of each separate charge against the defendant, and the Commonwealth has to prove the guilt of the defendant beyond a reasonable doubt. Mr. Hernandez is presumed to be innocent unless and until he is proven guilty beyond a reasonable doubt by the Commonwealth. The law does not require a defendant to prove his innocence, so Mr. Hernandez doesn't have to explain anything. He doesn't have to testify. He doesn't have to put on any evidence. His lawyer doesn't have to make an opening statement, argue, or ask a single question. Remember, it's the Commonwealth that has to prove the case beyond a reasonable doubt, and that burden of proof never shifts. At the end of the trial, you must find the defendant not guilty unless the Commonwealth has proved to you beyond a reasonable doubt each element of the offenses with which the defendant is charged. The trial will proceed in the following order. First, the attorneys have an opportunity to give opening statements. After one of the assistant district attorneys makes his opening statement for the prosecution, one of the defense attorneys may choose to make an opening statement immediately, may postpone doing so until later, or may decide not to do so at all, since the burden of proof of proving guilt is always on the Commonwealth. Next, the prosecution will call what witnesses it has in support of the charges that have been made against the defendant. After that, the defendant may present evidence if he wishes to do so, but he is not obligated to do so. Remember, the burden of proof is always on the Commonwealth to prove that a defendant is guilty. The law does not require any defendant to prove his innocence, to testify, or to produce any evidence at all. After the last witness has testified, the lawyers have an opportunity to argue to you about what conclusions you might draw from the evidence that has been presented. After all the evidence and the attorney's arguments, I will explain in detail the law that you are to apply in your deliberations when you retire to consider your verdict. That's how the trial will work. You may have noticed as you came in that there are cameras in the courtroom. Only authorized members of the media are allowed to take pictures or record proceedings or use a mobile phone or other electronic device in the courtroom. Under the rules that govern the media's use of cameras in courtrooms in this state, no photographs of jurors can be taken. With these instructions, we're going to take a recess before proceeding to opening statements because I have some matters I need to go over with the attorneys. Remember, don't talk about the case with each other or anyone else. We'll bring you back shortly.